Ladies and gentlemen, may I have your attention, please?
Covering both sides of the big issues with the analysis you trust on News Radio 1040 WHO.
Certainly one of the big stories of 2023 has been artificial intelligence and just how it's kind of swept right into our lives. It's been amazing, and we're really in real time trying to figure out what the implications of all of it is. So let's tackle one of the topics today. Let's say you use artificial intelligence and you get accused of violating a copyright. Who's liable for that? You? We're going to talk it over with the patent professor. He is an author of 2 books on patents and, of course, a frequent guest on this show on topics like this one. John Rizvi is back on my Davison Family Dentistry Newsmaker line. And, John, always great to talk with you on these topics. Good morning to you.
Good morning. Always a pleasure.
So, yeah, what are these big companies like Google and Adobe and Microsoft? They want you to use their artificial intelligence. What are they saying about if you get into copyright trouble?
Well, essentially, the equivalent of "come on in, the water's fine." But the worry here, and that you pointed out, is well, what happens when something goes wrong, right? Like, what happens if a user of one of these tech companies' AI gets sued for copyright infringement, doing nothing wrong, simply using that engine, and because the robot happens to have used copyrighted material, they get sued. So the problem with not just Google's statement, but other companies have followed suit, is that they're really vague, and we don't have any court decisions yet or precedent showing actually what Google is going to do. So a lot's going to be covered by the terms of service, and they're vague. They don't even include Bard, which is Google's AI, artificial intelligence engine, similar to ChatGPT.
And John, we all know what plagiarism is, but this is a whole new world, isn't it? Because AI is basically whatever the humans input into AI, right? So can you use existing plagiarism laws, do you think, or we're going to have to create whole new laws for this?
Yeah, so, the existing laws are stretched, to say the least. The problem is, in order to be entitled to copyright protection, there has to be a human author, and that's actually the constitutional basis for all intellectual properties, that there has to be an author. And the courts originally addressed this way back in the 1800s with the first photograph when it was copyrighted, and the question was, is the camera a human? And in that case, the court held that the camera is a tool, and the human made all of the important choices, the lighting, the angle, the subject, and there's enough human involvement and human control that was entitled to a copyright. So photographers have protection for their photographs. The problem is the tools have gotten more and more sophisticated, and the argument now is, for those that say that, hey, just because I use AI to create something, I should be the author of the piece, and that the AI is just a tool. And we see that a lot with graphics and art. They're trying to analogize using AI to a painter that uses a paintbrush or a sculptor that uses a chisel. The difference is that the paintbrush doesn't just go off on its own and you say, paint me a frog, and it goes and paints a frog. Every single brush stroke is controlled by the human being. So it's clear in those instances who the author is. It gets a lot muddier when you're dealing with these sophisticated computer programs,
right,
where the human input is like literally nothing. And the question is that going to be enough to entitle a human author to copyright protection?
Yeah. So, John, would it be fair to say that what you're trying to say at this point, let's say if you are Google, is, hey, once you ask the machine to do something, it's out of humans' control what the machine did, and therefore not subject to copyright law? Is that a fair interpretation of where we're at right now?
Yeah, and that I'm not sure. The honest answer is we don't know what the interpretation is. It's tough for intellectual property lawyers because that's the clients want to know, do I rely on this or not. The problem is each tech company has their own kind of terms of service that you have to agree to, and who really reads those? So when you read them, you really find out that there's a study that if you read all the terms of service, you'd be spending about 5.5 hours a week just keeping up with all the terms of service, and then they change, right? And what happens if they change? You sometimes you're under the gun. You need to catch an Uber. Something pops up saying we've changed our terms of service.
Yeah.
Like, are you going to read the 40 pages while you're standing there at the airport, or
right.
are you just going to hit accept and so you get to use the app? That's the issue. And even if currently Google has something, the terms of service that covers it, what are you going to have to do in order to qualify? It's almost like a warranty, right? In order to get something covered by warranty, the warranty is only as good as the fine print, the details. So, sometimes if, some warranties originally from the car manufacturers were so restrictive that if you didn't get an oil change at the dealership, the warranty wouldn't cover
right.
anything that went wrong. So it all comes down to those details, and that until we see what they are and how the courts are going to interpret them, because just because the terms of service change and a user hits accept doesn't necessarily mean that it's enforceable, right? There's limits on what companies can change in their terms of service, because I think the law realizes that not everyone's reading these terms of services. You can't, like if you have unrealistic, unreasonable terms that is a drastic change, they might need to do a lot more than simply have a button pop up in the process of you using the app. And even if it is, even the existing terms are, if people read them, they're ridiculous. Like on Twitter, everything you ever post, ownership is switched to Twitter, iTunes, similar, Facebook. They reserve the right to use your pictures, your data for anything in any capacity. So all of these are going to restrict what this, we've got your back if you get sued. Like, do they really have your back? We're not going to know until we see the first cases come through and see if Google actually steps up and offers a defense.
He is known as the patent professor, and it is a bold new world we're living in 2023. That's John Rizvi. John, fascinating conversation this morning. Thanks very much for talking with me.